that's something that happens as a matter of course with Schedule 5?
It has to happen. I know, Commissioner, that there are instances where the state is not opposing, even when the state is not opposing bail, and the prosecutor addresses the court from the bar saying, we're not opposing bail. I know of instances where the courts would have insisted at least on some form of evidence, formal evidence from the state, at least by way of an affidavit from the IO or so. And I do not have case law with me, but I know there's a case or two where the court would have also said, even when the state is not opposing bail, but the court is sitting, the court needs to be assisted by the two parties. And even when the state is not opposing bail, but you, as an officer of the court, you have to address the court, say why you are not, give this information to the court. So if you have compiled an affidavit, it's easier for the court. You read it into the record saying these are our reasons. And when the court evaluates whether or not the accused has met the onus of proving that it's in the interest of justice that he will be on bail, the court has the benefit of both the state and the applicant's evidence. But in this case, the bail application or the statement was not done, which was one of the things that made me realize that this team did not appear to have been ready for this bail application. I would have expected them to, because when we were in court, I then asked Brian, just before addressing the magistrate, I asked him, did you compile an affidavit? Because now I could see the magistrate was going to engage me. So I wanted to speak out of an affidavit, not just give the court information which I was not privy of. But I remember asking him about the issue of the list, and then quickly he said, no, we have other outstanding investigations against some of these people. So that is why we don't want the list of these people to be known, because if we list them, that's going to impact on our outstanding cases. And that is what I then delivered to the court when the court was asking Tlatrayo, why not the list? I'm at the paragraph where the magistrate invites me to address him, and before doing so, I then asked Padayashi whether a bail statement or affidavit had been prepared. It had not. Mr. Padayashi explained that the witnesses had been told that if they were contacted by the accused, they should immediately report to him, so that there was no danger in that regard, and that there was a further ongoing investigation involving the same accused. Such listing of the witnesses could disclose their identities and the existence of that other investigation. This is what I delivered to the court. On that...
Sorry. So where you say in line 1, 2, 3, 4, 5, there's a sentence that starts, so that there was no danger in that regard. It's preceded by where Padayachi explains to you that witnesses have been told that if they are contacted by accused, they should immediately report it to him. And then you say, so that there was no danger in that regard. Can you just explain what you're addressing there?
Yeah.
Where you say, so that there was no danger in that regard.
Yeah, I think what I wanted to say here was that Padayachi and his team would have discussed with the witness to say, if anyone contacts you, please let us know so that they can take steps. So I'm saying, so that there was no danger in that regard. The quicker they are alerted, the investigating team is alerted, then the danger could be averted.
Okay.
On that basis, at paragraph 31, on that basis, I then addressed the court and requested that the witness not be listed, so as not to compromise the other ongoing investigations involving certain of the accused. Out of respect for the court, I could not decline to address the court when the magistrate invited me to do so. At 32, bail was fixed for the accused in the amount of 10,000 rand each, save for accused number 2, Mr. Lushaba, who was not admitted to bail at that stage owing to a separate outstanding matter, and the matter was postponed. Among the conditions imposed by the magistrate was a condition that the accused do not enter the premises of crime intelligence anywhere in the country. Neither the state nor the investigating officer had requested that condition, and the magistrate gave no reasons for imposing it. Of significance is that in the course of granting bail, the magistrate himself remarked that he was not persuaded that the state had a strong case, and indicated that this was among the consideration that moved him to admit the accused to bail. He observed that the matter was not a typical fraud or corruption case. This doubt was expressed by the presiding officer at the very first appearance. It's there on record, Commissioner. The magistrate says it after asking Advocate Hlajwayo some questions. He says, I'm not that convinced that your case is that strong because it's not like the typical cases that we deal with of fraud. And he also says it to the accused when he grants them bail. He says one of the things that I've considered is this issue, and I'm not convinced about the strength of the state case as it stands, based on the address by the prosecutor. The record speaks for itself on that issue. At 34, my involvement then ended after the first appearance.
Can I just ask you, so you stayed in court the whole time until the court rose?
Indeed, Commissioners, I stayed in court until the matter was, the bail application was finalized.
And where was Mr. Padiachi by the time court rose?
Mr. Padayashi was with us up to a certain point, I think just before the judgment, because he had to catch a flight back to Durban, Port Elizabeth. He's based there, he stays there, so I think he comes to the office after every second week. There's an arrangement that they have in the office. So I remember he had to go back, rush to airport to catch a flight. So he kept on saying to us at the time, guys, I'm going to leave you. I'm not going to stay until. So he left at some point. When the magistrate was delivering judgment, he was no longer there. He left.
More specifically, when the debate or discussion about conditions was happening, do you recall whether he was in court or not?
He was still in court, because I also asked him, that's when I asked him, do you have a bail statement? Have you prepared a bail statement? And when Hlajwayo was addressing the court about the conditions, he was still there. I think he left just before the magistrate had started delivering judgment.
Thank you.
Yes.
Advocate Ray, before you move to the 8th to August, when you come back from court and having seen what you've seen that day, from the moment where you were consulting your colleagues to what you've then witnessed in court, did you do a report to either the ID or Mr. Sissoko on the developments of the day? In particular, your concerns?
Yeah. I did not, because at least at this stage, I did not have enough information that I later got. At least at this stage, in my mind, I'm thinking there's a team that is dealing with this case, but it's strange that only one prosecutor and one investigator are in court, and the DPP that I expected to be involved in this does not seem to know about this case, because he's not with them, and I saw him in the office. But, you know, and I could see that they were not ready. There was no bail statement. But after that, my involvement literally ended there. And what we do in the office, when I would have expected Advocate Hlajwayo to do the reporting to the ID. That is what we do when we come back from court, especially in this type of cases. This was a very big case. I mean, generals in the intelligence service, you know, one would have expected a report to be given to the ID to say, this is how we fared, this is what happened, and the case has been postponed to such and such a case. Personally, I did not, at least at this stage, I did not make any report because I was not part of the case. My involvement was to help on that day, and I think I did my level best on that day, and that was the end of it.
Suppose the question is, I understand the report as it relates to what happened in court and where it landed, where bail was granted, conditions and all of that. But in this instance, what you knew that day was that there was no DD, there was no senior prosecutor. They certainly didn't appear to be ready for the bail proceedings. You had to step in as somebody who's completely not involved. This was run by the most junior prosecutor, you say, at the time. It seems to me that beyond the reporting about the progress of the case and what happened in court, there was other issues